Hello friends, today we are going to discuss patent grant process in India. The first stage is complete specification, which includes filing of relevant forms plus the draft of the patent application, which must cover claims, description of the embodiments of the invention, and the drawings. It is important that complete specification must satisfy the best mode as well as the enabling requirement. However, you can also see there is a one more optional filing which is called as provisional patent application. The provisional patent application is filed in scenarios when you do not have sufficient time to prepare the complete specification. In scenarios such as you want to have an early publication in some conference, or the marketing team wants to launch a product and they do not have any sort of protection for your invention. In such scenarios, you generally file a provisional patent application. Why do we need to file a provisional patent application? The reason of filing provisional patent application is that all over the world it's first to file system. A person who files first will be entitled to get a patent application. So everyone wants to get a filing date which will become your priority date for all the foreign patent applications. Once you have filed a complete specification, then the next step would be the publication. The Indian Patent Office gives you two types of publication methods. The first method is 18-month publication, where Indian Patent Office goes by statutory guidelines that your patent application is going to be published within 18 months from the date of either the provisional application or the complete specification filing, whichever is earlier. You have another method also to get your application published earlier than the 18 months. How you can do it? You can simply file a request for early publication, and Indian Patent Office will be publishing your application in their official journal within 2 to 3 months from the date of filing of early publication request. After publication stage, the next stage is examination stage. What happens in the examination stage? The Indian Patent Office is going to issue objections to your patent application in the first examination report. The first examination report we can generally refer to as FER. After the issuance of FER, the applicant needs to reply to the objections of the Indian Patent Office. At times, you may confront with the understanding of the examiners with respect to your invention, so that you can completely satisfy the examiner that your invention is novel, inventive, and has an industrial applications. If you do not comply with the objections issued in the FER, the Indian Patent Office may issue a second examination report. Else, the Indian Patent Office may issue a hearing notice. In the hearing notice, you will get an opportunity to directly interact with the examiners of the Indian Patent Office, either through a physical hearing or through a hearing video conferencing session. So, in these sessions, you will get an opportunity to explain your invention in detail to the examiner. On your behalf, the same processes can be done by the patent attorney. So, once the examination stage is complete, after that, the Indian Patent Office can issue a notice of allowance to your patent application. What does this mean is This is the news which you would like to hear from the Indian Patent Office. This means is that your patent application, after going through all the various stages, have now been granted. And now you are an owner of a patent in India. You can stop your competitors from selling, manufacturing, importing, exporting the products or the methods or processes for which you have been granted patent. Without your permission, they cannot do any such activities. If they still do, you can enforce your legal right which has been granted now in the form of a patent against these willful infringers. That's all from our side as of now. Keep tuned to the Legal Canteen for further updates on legal issues. Thank you.